Hi, my name is Paul Wayburne. I'm an immigration attorney from Irvine, California. This video is about marriage-based immigration and which pathway is the right one for you. There is a joke that is sometimes said in relation to marriage, that there are three rings: the engagement ring, the wedding ring, and the suffering. Jokes aside, we know that life-changing events can bring about a lot of stress and challenges for families. We know that buying a home, the birth of a child, a new marriage, a divorce, a health crisis, and the death of a loved one can challenge marriages in profound ways. The same applies to immigration. When deciding upon an immigration pathway, it's important to bear in mind the advantages and disadvantages of each option. The cornerstone of any marriage-based case is the existence of a good faith marriage. If one is not a party to a good faith marriage, one is not eligible for immigration benefits. One also commits fraud if you're applying for an immigration benefit on the basis of that marriage. More so, if a person is not part of a good faith marriage, a person's American immigration journey can be a very painful one. But even in a typical marriage, immigration can challenge the stability of a marriage and a person's sense of self-worth. Therefore, when considering an immigration pathway, the personal dynamics of the couple and the family must be considered. Regarding blended families, the stresses can be even more overwhelming. This is not just a marriage between two people, it's a marriage between families, an American family and a non-immigration family. For the purpose of this video, I will assume that neither party to the marriage or a stepchild is otherwise inadmissible to the United States. So I'm going to talk about three potential pathways. The first is the K-1 fiancé visa pathway. The second one is applying for a green card based on marriage inside the United States. And the third is applying for a green card outside the United States. And I'll discuss each one in turn. Please listen carefully. The K-1 fiancé visa pathway is one route. To qualify, the petitioner and the beneficiary must be eligible to marry one another. They must not otherwise be disqualified from immigration and must have met one another within the last 2 years. Importantly, this pathway is only available to a US citizen petitioner and not a permanent resident. There are three stages to the K-1 visa pathway. The one is filing a petition for alien fiancé with USCIS with proof of an in-person meeting within the last 2 years and undertaking to marry and evidence of a good faith relationship. The case is then transferred to consular processing after quite a long time. As part of that process, the US citizen fiancé must prove that he or she can financially support the prospective immigrant and also that the prospective immigrant qualifies for immigration. Once approved for immigration, the foreign citizen fiancé has a limited time to come to the US. Once he or she has arrived in the US, the couple must marry and file for a green card within 90 days. Otherwise, the person who holds the K-1 visa will become deportable. It is important to make clear that the foreign citizen fiancé may not work in the United States until he or she receives work authorization. People generally don't like this pathway because it takes a long time and people get impatient with the process. Furthermore, work authorization can take a long time to come. There's the time that the petition is prepared. Even after filing, it can take anything from 4 to 9 months to obtain employment authorization. And this can be quite difficult for a couple who's party to a marriage. So it's important to bear in mind that it takes time for the process to unfold. And secondly, one does not have employment authorization immediately upon arrival in the United States. One has to wait for that to come. And so this can create a lot of problems in a marriage if one party to the marriage is not eligible to work, especially if they're reliant on two incomes. Very important. One could also apply for a marriage-based green card inside the United States. So many people, especially newlyweds, might want to immigrate and marry one another as soon as possible. So they look for the quickest pathway to come to the US. The foreign citizen might have a tourist visa or some other type of visa that permits them to come to the US. However, as long as a person has been lawfully admitted to the US and there exists a good faith marriage, a person is not otherwise inadmissible to the United States. He or she can file for a green card inside the United States based on marriage to a US citizen. There are advantages and disadvantages with this approach. The first is the problem of preconceived intent. In other words, when a person arrives in the United States on a non-immigrant visa, one is essentially representing to the border officer that one is coming to the United States for a limited period of time with non-immigrant intent. If one marries a US citizen or files for a green card within 90 days, there is a presumption that he or she misrepresented to the border officer that they had non-immigrant intent. The presumption falls away after 90 days. This doesn't mean that preconceived intent isn't a problem. It just means it's not much of a problem. Many couples successfully obtain their green cards after coming on a tourist visa. But it's got to be carefully thought out whether this is the best pathway because of the problem of preconceived intent. However, even if you're able to overcome the problem with preconceived intent, you have to wait for 3 months before filing anything. And even once you file for a green card, you have to wait for employment authorization. And this could also take a toll. Remember, the person who's immigrating to the United States doesn't have a proper immigration status until they obtain a green card. And so they might find it difficult to live in the United States without a social security number and just participate in society as a normal person. They also might have difficulty getting health insurance. So it's always important to take into account whether it is important to come to the United States and live together as soon as possible, or just be patient and wait. Wait for the process to unfold either with a K-1 visa or just apply for a green card outside the United States. And to me, I often recommend that if a couple can live outside the United States, it's far better to apply for a marriage-based green card outside the United States. And I'll tell you why. Because you can live in your home country with all the rights and privileges and obligations of citizenship. You can work, you can live, you can buy a home, you can go to the bank and open a bank account, or you can come to the United States and find it difficult to do any of those things because you don't have proper status. So if you apply for a green card outside the United States, yes, it might take 1.5 years to complete, but you get to live like a normal person inside your home country. And when you come to the United States, the moment the immigration officer puts a stamp on your passport, you walk in as a permanent resident and you can live here like a normal person. You'll get a social security number, you'll have your green card, and you can start working immediately. And this is often the best approach, people who are party to a marriage, because they've prepared for 1.5 years for the moment of immigration. They come here. And now all they need to do is deal with the cultural adaptation that one inevitably has to deal with when one immigrates. But they can work, they can become a student at a university, they can open a bank account, you can buy a home, you can do so many things that a person who comes on a tourist visa cannot do. For most people who can remain in their home countries, this is a really good idea. Sometimes it's not practical and other avenues need to be thought out. So please contact us below if you would like to discuss which pathway is best for you. Thank you very much.